924-071. Call for an automatic stay while
they were aggravators. They go to membership, and again, there are things that the jury would have to find before going into penalty.
Not aggravated as to the death penalty, aggravated as to the gang enhancement itself, Your Honor. That's charged. He was charged in committing the murder for the furtherance of the gang, which is an aggravator in terms of the guilt.
Something that they would have to find by way of an interrogatory.
Yes.
The reason Melly doesn't care if the evidence is included or not is because if his lawyers gets that evidence thrown out, the paperwork that comes alongside it will make the trial begin in 2027, meaning that YNW Melly will have been sitting in jail for 7 to 9 years before being convicted of the crime.
I do find this case to be under the most compelling circumstances. Mr. Devins, as I sit here today, has been in custody for 2,339 days. Besides Mr. Devins' cases, which I've removed, this division currently has 38 other cases, special set for trial. 22 of those are murder cases. Numerous of those are death cases. And right now, this division has trial special set in December of 2026.
He stood up in court, yelling at his own lawyers. YNW Melly just made a shocking move that could destroy his entire case. Secret footage, tampered witnesses, and a jail phone scandal. This is more than a trial. It's a ticking time bomb. And what happens next will blow your mind. Watch till the end, because the biggest twist is still coming. In a dramatic and unexpected turn at his latest court hearing, YNW Melly took a bold step that rattled the foundation of his own defense team, signaling a seismic shift in his legal strategy and, perhaps in the outcome of the case itself. What was supposed to be a routine update, a mere procedural hearing where the possibility of an early release date was quietly mentioned, quickly spiraled into a scene heavy with tension, raw emotion, and a very public display of rebellion. For the first time since the trial began, Melly openly defied his attorneys before the judge. Something reporters described as a courtroom bombshell that immediately altered the atmosphere. One could practically feel the air grow heavy as he stood from his seat and loudly challenged his lawyers, making it abundantly clear he had reached boiling point. Emotions were raw, voices trembled, and the judge's gavel, usually a symbol of calm authority, felt far more precarious than usual. As the chaos unfolded, one of Melly's own lawyers, visibly uncomfortable, yet trying to maintain control, took the stand to acknowledge the upheaval. "Yes, Your Honor," he said, his voice tight, "against our advice, our client has chosen to proceed this way." Another defense attorney stepped in, echoing the tension. "You asked us to request an automatic stay, and that is exactly what our client insists on." The exchange told a clear story. Melly was willing to shatter the cohesion of his legal team in order to assert his stance and regain some form of agency in a trial where he had often felt sidelined. The heart of the dispute's emotional and legal center was gang affiliation. Prosecutors contend that Melly's alleged ties to gang activity serve as an aggravating factor that must be weighed by the jury, influencing both verdict and sentencing. Convincing a jury that a defendant has gang ties often adds a layer of societal danger and intent, making it more difficult for the defense to argue mitigating circumstances or lesser charges. For prosecutors, these ties are not just a footnote, they represent usage of collective intimidation, influence, and an expanded circle of criminal complicity. For the defense, the goal has always been to sever that narrative, presenting Melly not as a recruiter or participant in organized criminal behavior, but as someone trying to escape violent streets, not enable them. That's why Melly's outburst, his resolute declaration of, "I don't care, I'm not in no gang, they can't prove that," dropped a bombshell. Not only did it lay bare his anger with the strategy of playing along quietly, but it also served as a symbolic move. He was rejecting the framework that the prosecution had built over years of research, informal interviews, and cross-referencing of music, social media, acquaintances, and physical evidence. His refusal to accept a plea bargain that possibly included an admission of gang affiliation made it clear he could be willing to risk more in the hopes of clearing his name completely. Sources say that his legal team is now dealing with an ethical and strategic dilemma. Do they continue negotiating with prosecutors for a plea or sentencing reduction that depends on some degree of admission and thereby betray their client's personal claims, or do they go all in on trial strategy, doubling down on suppression hearings, bringing in expert testimony on rap lyrics not equating to criminal code, and challenging digital evidence? The room is reportedly charged. Some internal sources say the defense is splitting into factions. One side sees the outburst as a distraction that strengthens the prosecution's case. Another views it as a necessary reset that could win public support and potentially appeal. Jurors tired of seeing Melly portrayed as a violent gang member From the courthouse hallway to social media, reactions have been furious. Melly's fanbase rallied behind him, cheering the outburst as a sign of authenticity and defiance. Some influencers argued that he's not just rejecting a legal strategy, but challenging an entire system that criminalizes Black youth simply for association, for music, for expressive identity. Prosecutors, meanwhile, have doubled down on their existing evidence gang crosstags. Coded lyrics, pistol postings, audio recordings linked to masked murders. In recent weeks, they've introduced new testimony from mental health professionals who have conducted assessments on Melly, describing someone who thrives in group loyalty and who has unquestioned emotional ties to people believed to be active gang members. When the judge called the session to order after the dust had begun to settle, she took a moment to remind everyone of the gravity of the situation. "This is not entertainment," she said, "not a performance. This is a man's life at stake, and decorum and the rights of the defendant must be respected." She acknowledged Melly's right to speak, but also reminded his counsel they retain ethical duties to ensure accurate legal representation. That moment underscored how dramatically the hearing had shifted, turning a routine session into a crucible for legal ethics, public spectacle, and the future of a young rapper whose career, voice, and freedom now hang in the balance. As Melly was let out, custody of the mic returned to his team. Their next move is critical. They must choose between negotiating again, including possibly facing harsher terms, or pressing on toward trial. While optics are tense, public opinion is watchful, and jurors are being selected from a pool increasingly attentive to every tweet, live stream, and courtroom moment. Prosecutors are reportedly circling evidence files, scanning for moments like this, moments that can be turned against Melly as proof of uncooperative, unremorseful behavior. Whatever happens next, one thing is clear: YNW Melly has shaken the dynamic behind the scenes. A defendant spoken for has now chosen to speak out directly, emotionally, and not according to the talking points of his own legal team. Whether that strategy pays off or collapses remains to be seen, but in that moment, he made a public stand. He rejected part of his own defense and issued a challenge to the court, the prosecution, and the world. And justice, as the system defines it, may soon move forward, but whether that justice will align with YNW Melly's truth is a question that no bail bond can contain. One of the state's arguments was that Melly committed the crime as part of a ganga claim that, if accepted, could significantly increase the severity of his punishment. But for that to happen, the jury would need to be convinced beyond doubt of his gang involvement, which is still under intense scrutiny. Ironically, Melly's apparent indifference to whether the evidence stays or goes might stem from a deeper reason. If his lawyers successfully get the gang evidence excluded, the legal procedures tied to that move would delay his trial until at least 2027. That would mean nearly a decade behind bars without a conviction, something Melly clearly wants to avoid. The chaos surrounding YNW Melly's second trial has intensified, with prosecutors now pushing for a delay, not to stall, but to fight for the inclusion of key suppressed evidence that could help them secure a life sentence. Judge Murphy reaffirmed that much of this material, originally tied to alleged gang affiliations and death penalty enhancements, remains off-limits unless the state successfully appeals to a higher court. If the appellate court grants a stay, the trial could be postponed, giving prosecutors time to fight for the evidence. But without that stay, the trial moves forward on September 10th, with the current restrictions in place. This ruling sent shockwaves through the courtroom and beyond, with Melly's mother going live on Instagram to confirm the trial date and the judge's firm stance. The suppression of this evidence is a major blow to the prosecution, drastically limiting their ability to argue for the harshest penalties. Meanwhile, Melly's defense appears to be shifting strategy, moving away from emotional appeals and toward highlighting procedural flaws, reinforcing that the prosecution's strongest tools were deemed inadmissible. Behind the scenes, both sides are scrambling, prosecutors preparing for a possible appellate fight, and the defense readying for trial without the fear of death penalty evidence. As the clock ticks toward September, the battle is no longer just about guilt or innocence, it's about what evidence gets to define YNW Melly's future. As the hearing came to a close, YNW Melly's legal team made a last-minute plea that many had been anticipating for months, a formal request for bond until his scheduled trial in September. The courtroom, already tense from a series of emotional and strategic exchanges, fell into a heavy silence as the judge considered the motion. But in the end, the answer was firm: bond denied. The blow was felt immediately, not only by Melly and his defense team but also by the supporters who believed that after more than 6 years behind bars without a conviction, he might finally get a chance to breathe free air. To put it into perspective, Melly has now spent approximately 2,320 days in jail, awaiting trial, locked away without a formal verdict. That kind of pre-trial detention is rare. And the court's refusal to grant bond sent a clear message: the state believes it has a solid case, and the risk of releasing Melly is too great. What tipped the scales so definitively? The prosecution came armed with fresh ammunition, a trove of newly compiled evidence that painted Melly not as a misunderstood artist caught in a legal nightmare, but as a dangerous individual who could pose a flight risk or a threat to public safety. Central to their presentation was a piece of surveillance footage that, until now, had not been shown to the public or even the defense in open court. The clip reportedly captures Melly making statements that amount to an indirect confession, just hours after the murders of his two close friends, Anthony Sackheiser Williams and Christopher Juvie Thomas Jr. In one particularly unsettling video, recorded a mere 5 hours after the shootings, Melly and co-defendant Cortland Bortland Henry are seen dancing casually in a dimly lit parking lot. There's music playing, laughter heard, and an air of carefree celebration that prosecutors argued was wholly inconsistent with the behavior of someone grieving the violent deaths of two lifelong friends. The footage, described by courtroom insiders as haunting in its detachment, was presented alongside a detailed timeline constructed by the state. Prosecutors argued that this clip demonstrated not only Melly's lack of remorse but also his attempt to continue life as if nothing had happened. Behavior they claimed was consistent with someone trying to cover up guilt rather than process grief. Even more damning was a second surveillance video, time-stamped roughly 30 minutes before the murders occurred. In it, Melly is seen leaving a recording studio with several friends. As the group approaches a black Jeep, Melly clearly enters through the rear driver's side door, placing him in the back left seat. According to forensic experts and police investigators, that exact position aligns with where the fatal shots were fired from. Ballistics testing and blood spatter analysis later revealed that the bullets traveled from left to right, consistent with someone sitting in the back left seat shooting across the cabin of the vehicle. The prosecution took their argument a step further by calling to the stand Juvie's mother, who emotionally confirmed the seating arrangement of the group that night. Through tears, she told the court that her son always sat in the front passenger seat and Sackheiser usually sat directly behind him. The implication was clear: if the forensic trajectory analysis holds, the shooter would have been seated where Melly was seen entering just half an hour before the killings. Prosecutors also hinted that this was only a portion of what they planned to show at trial. They mentioned additional digital forensics, including cell tower pings, metadata from Snapchat and Instagram, and private DMIs that allegedly show coordination between Melly and Bortland after the incident. Some of these messages reportedly include coded language that prosecutors believe demonstrate intent, premeditation, and attempted cover dash-up. This presentation wasn't just about blocking bond. It was about reshaping public perception and preparing the courtroom for what's coming in September. They weren't arguing from emotion. They were laying a foundation. In doing so, the state made it nearly impossible for the judge to justify releasing Melly. Even if the actual trial is still weeks away, the prosecution sent a message: the evidence is mounting, the timeline is tight, and their case is being sharpened into a spearhead aimed directly at the defense's core narrative that Melly is an innocent artist caught in a tragic misunderstanding. As Melly was escorted out of the courtroom in cuffs, his expression was blank, but his legal team looked visibly shaken. Outside, supporters gathered in small groups, some still hopeful, others beginning to reckon with a sobering possibility that the walls might finally be closing in. And with every new piece of evidence brought into the light, the case that once felt like a complicated he said, she said has started to resemble something much darker and far more conclusive.
Cortland Henry contained 0 particles characteristic of hot residue and two component particles. And
just when the case against YNW Melly seemed to hit its limit, prosecutors brought forward even more shocking evidence, raising serious concerns about the Florida court system. They managed to flip 2 key figures: Melly's ex-girlfriend Mariah Hamilton and co-defendant YNW Bortland. Mariah had been outside the U.S. since before Melly's first trial, with investigators alleging he either paid her or pressured her to flee so she couldn't testify. But when she returned to visit family, she was arrested at Miami International Airport. It was her first time behind bars, and the experience broke her down quickly. In her very first court appearance, she accepted a deal, testify truthfully, against Melly in exchange for her freedom. She was released and later posted on Facebook, thanking her community and calling it God's plan. But what made this more than a simple deal was what agents had already discovered in her iCloud. Messages and files allegedly show Melly encouraging her to avoid testifying evidence of witness tampering. If she confirms it, Melly could face life in prison, even if he's acquitted of the double murder. The state has now filed 6 new charges, including tampering with a witness, criminal solicitation, and illegal use of a communication device. Some of these carry life sentences on their own, and the scariest part, these charges are completely separate from the murder trial. Even if he's found not guilty for the deaths of Sackhazer and Juvie, a conviction on witness tampering alone could still keep him behind bars for life. Adding to the pressure, Melly hasn't been allowed to use jail phones for months. His mother, Jamie King, spoke out, saying he's being denied basic rights, like phone calls and mail even, though he hasn't been convicted. The likely reason, officials suspect he was using the jail phone to tamper with witnesses, and they wouldn't impose such a restriction without hard evidence to back it up. Meanwhile, things between Melly and YNW Bortlin are clearly falling apart. In the first trial, Melly's lawyer wasted no time pointing the finger at Bortlin. He claimed Bortlin drove the victims to the hospital, changed clothes, had gunshot residue on his hands, and lied repeatedly to authorities. The defense even brought in a forensic expert to confirm Bortlin tested positive for residue, and emphasized that he was the last person seen with Sackhazer and Juvie before they died. What many people don't realize is that this is also why YNW Bortlin, Melly's longtime friend and co-defendant, has been completely silent on social media for over a year. While some assumed he was simply staying out of the spotlight, others now believe his silence was strategic, a calculated pause while legal negotiations unfolded behind the scenes. But all of that changed the very same day YNW Melly's mistrial was announced. In what many took as a deliberate move, Bortlin broke that silence with a single cryptic tweet: "Mind games don't work on people like me," followed by a handshake emoji. It wasn't much in terms of length, but in a case already full of coded messages and layered alliances, that one line spoke volumes. It didn't take long for fans, legal analysts, and even reporters covering the trial to start speculating. Was Bortlin sending a message to Melly? To prosecutors? To both? Some insiders suggested the tweet might indicate that Bortlin had accepted a plea deal, was, at the very least, weighing the possibility. When you've been facing decades behind bars and suddenly find yourself tethered to a co-defendant who could bring everything crashing down, silence becomes more than just smart, it becomes survival. And shortly after that tweet, the speculation gained traction when court documents revealed that the state had officially filed to have Melly and Bortlin tried together in the upcoming retrial. This move wasn't just procedural, it was strategic. Prosecutors know that trying both men together consolidates the case. It means they only have to present the evidence once, and more importantly, it puts pressure on both defendants to consider their options carefully. It's a classic prosecutorial maneuver: keep the alleged accomplices close, knowing the closer they sit in court, the harder it is for one to stay loyal if the other folds. From a legal standpoint, this joint trial serves the state well. It allows them to present a unified narrative, one in which both Melly and Bortlin were not just present, but actively involved in planning, executing, and attempting to cover up the murders of their close friends, Sackhazer and Juvie. The defense teams, unsurprisingly, pushed hard for separate trials. Their entire strategy likely depends on the ability to shift blame from one defendant to the other, something much harder to do when both are sitting just feet apart, listening to the same testimony, watching the same surveillance footage, and hearing the same damning evidence. But despite their objections, the court ruled in favor of a joint trial. The judge emphasized that while the state is only seeking the death penalty for Melly, not Bortlin, the penalty phase is entirely separate. What matters first is the guilt phase, which applies equally to both men. If they're found guilty, only then do the questions about punishment diverge. And this is where things get even more serious. If Bortlin is sitting in court, staring down the possibility of spending the rest of his life in prison, and he knows deep down that he didn't pull the trigger, the stakes become impossible to ignore. Up until now, he's remained loyal. He hasn't given interviews, hasn't lashed out online, hasn't pointed fingers. But loyalty has limits. especially when your own life is on the line. The pressure to speak up to protect himself could become overwhelming. And if Bortlen does decide to talk, to cooperate in some capacity, or even to testify, it could spell disaster for Melly, because no one knows the details of that night better than Bortlen. He was there. He rode in that Jeep. He was part of the immediate aftermath. His testimony wouldn't just be powerful, it would be devastating. This is the reality Melly faces now. He's not just up against prosecutors or evidence, he's up against time, pressure, and the crumbling wall of silence that's kept his case from falling apart. If Bortlen breaks ranks, the trial could take a sharp turn, shifting from a battle over forensics and timelines to a direct accusation from a former brother-in-arms. And in cases like this, juries don't forget betrayal. They don't overlook personal insight. When a co-defendant testifies, it often seals the outcome. Prosecutors know this. They're counting on it. And while Bortlen hasn't confirmed anything yet, his silence, his tweet, and the new legal developments all suggest one thing: the clock is ticking, and someone is about to talk.